Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming question and answer show. My name is Andrew Feldstein, and I'm the principal lawyer at Feldstein Family Law Group. We have offices in Vaughan, Markham, Mississauga, and Oakville, and both myself and all of our lawyers exclusively practice in family law. And today I'm joined by one of our senior associates, Miss Anna Troitschanski. Welcome to the show again, Anna.
Thank you for having me. Thank you for
Today's
having me.
Today's topic is about the division of property. We're focusing on what one spouse is entitled to after they separate. So I thought I would start the process off. I know people come in and they often think, well, it's really simple. I'm just entitled to half. And I want you to think about it from the perspective of you have that client, they're in the office for a consult with you, and they say, well, don't I just get half? And is that the whole story?
No, absolutely not. It's a lot more complex than that. And, one of the first things that we begin with is identifying all of the disclosure and understanding what assets each party has an interest in. And the way equalization works in a nutshell, and I'm sure we will discuss this a little bit more as we chat today. The party with what we call the higher net family property pays the party with the lower net family property half of the difference. So it's not exactly a 50-50 analysis.
Well, the idea of paying half the difference, the term we use is equalizing net family property. So what that means is if the person with the higher net family property has $1 million and the person with the lower net family property is a half a million, half the difference would be 250. And that way each of them would end up with 750,000 at the end of the day. And I think you'd agree with me when a lot of people, they may just own their home and they have a pension or some RSPs. And those cases are relatively simple and straightforward and easy to calculate. Would you
That's
agree
right.
with that? But where Anna and I spend a lot of time isn't necessarily on that easy case where there's a home, it's jointly held, it gets sold, we put half on each side of the ledger, pay out the mortgage, and the parties can go their separate ways from a property perspective. We deal with a lot of cases that are far more difficult. And for example, what would you say are some of the wrinkles that makes things more challenging in the calculations of equalization of net family property?
Well, there are many. I mean, for one, when we start dealing with inheritances or gifts or date of marriage deductions. People don't always have the evidence that they require to prove some of these things or to trace some of these things. And that's where the complexity comes in. When we're dealing with complex businesses and you require some very detailed business valuations to be done, that's another area where there could be disagreements on what is the value that we should be attributing to certain assets. And so I think the higher the net worth a client is, the more complexities there are surrounding the division
So
and,
let's
and
break, so
ascertaining.
let's break it down. I like sometimes to work in headings. You mentioned data marriage deductions, you mentioned gifts, you mentioned inheritance, you mentioned businesses. So let's work with those four items right now. And the first one I'm going to start with is a data marriage deduction. What does that mean for our viewers? Well, when we calculate equalization of net family property, we take one person's net worth on the date of separation and we subtract it by their net worth on the date of marriage, because what we're trying to do for each party is determine how much their net worth grew during the course of the marriage. We call that growth the net family property.
That's
Then
right.
there are certain exceptions to those calculations, which are inheritances, gifts, money from a personal injury claim, money from a life insurance policy. Those are some of those examples. So when we start with data marriage deductions, one of the things you really said that struck me is proof. So here's where the example is. When you get married, you can't just say, now it's 20 years later, I'm separating and I had $500,000 in a bank account, so I want a deduction. Because what does the case law on that say, Anna?
Well, the onus is on the person trying to seek the deduction to prove that it existed at the date of marriage.
So
So
I would,
telling somebody that I had it, doesn't get you very far. You need to get the proof. And the problem is the longer the marriage, the more difficult it is to obtain that proof. Bank statements are held by the banks, I think, usually for about 6 years. And after that, they are destroyed or whatever it is that the bank does with them. So you can't just necessarily call your institution and say, can you produce these bank statements from, 15, 20 years ago that show that I had, $200,000 on my account at the date of marriage. So unless you're one of those people that tends to keep a lot of these records or keep these old bank books that used to exist or anything to that effect, you're going to have a hard time proving that date of marriage deduction. And sometimes those numbers go a really long way for the purposes of equalization.
so here's what I recall. When I started my practice and before everything was on computers, I'd say to my client, do you have that bank statement? And I remember when I grew up, my father would keep every bank statement. He'd put them in a file folder and he could have a file folder of 20 years of bank statements in his office at home. But there was the mistake if you went through a divorce, because what I said was it was in the filing cabinet at home. So I'd meet with someone at a consult and they'd say, don't worry, Andrew, I have it at home. An hour later, I would get a phone call, Andrew, it's gone. They couldn't believe it. My ex-wife, my ex-husband, they threw it out. And I'd go, why are you surprised? One piece of paper that shows $500,000 is going to put $250,000 after taxes in your pocket, and it's gone. So what have I often said when I'm at a cocktail party or talking to friends or family is that, first of all, get a marriage contract, but let's assume you don't get a marriage contract. Let's assume you don't have one. At the very least, keep that proof. So if you have that bank statement, keep it, digitalize it, keep hard copies, keep it in safe places. And when I say safe places, I don't mean keeping it in the house where your spouse can take it. I mean keeping it in a place where your spouse can never take it.
That's right.
And, I remember when I went through my divorce, how upset my ex-wife was that I put all my paperwork in a safety deposit box that was solely mine. So when we separated 15 years later, here's the bank statements. Here's my corporate statements. It was very easy for me to prove it. Most people aren't like that, but that's what you should be doing, is keeping proof of it if it's substantial enough. And don't ever think giving it to your best friend is a good idea to hold on to. Because I always remember the one where my client found out that the best friend holding on to the critical paperwork was also the mistress.
Yeah, that
So
happens.
you got to think about who you're going to be protecting yourself from. So the point is, paperwork is important. And if you have real money and you didn't have the courage to ask for a contract, which is fine, at the very least, keep the proof of what you own on the date of marriage. Now, I'm going to jump aside to one item we didn't talk about, but I'm going to just say we're going to talk about it later, is what to do about the matrimonial home, because it has some funny rules to it. The other thing you mentioned was an inheritance. Now, we call those exclusions. Can you explain what an exclusion is for our viewers?
So an exclusion is essentially an asset or value pertaining to an asset that is taken out of the calculation. But there is some caveats to that, because with respect to an exclusion, you first of all need to prove the exclusion. You need to prove that it was a gift or an inheritance that was given only to one of the parties, not both, and it wasn't commingled in joint assets. And you have to be able to trace it to a data separation asset. It may be in a different form, which is fine, but you need to be able to trace that without having commingled it throughout the process. So it's not an easy task, but for some individuals, it's something that they can demonstrate. Sometimes when people speak to us, before they get separated, and they say, I'm expecting this check from my father that's going to come in, one of the greatest pieces of advice that I think we give them at that point in time is make sure it's going into a separate account and that it's very clearly either staying there or if it's being transferred out, that you're able to trace it, because otherwise you lose that exclusion.
So I think the key words are may lose exclusion because one of these biggest challenges, again, if I get an inheritance 15 years ago, that means I need to be able to show, like Anna said, I got the inheritance and then I have to trace it. May sound simple, but if it's 15 years later and you put it in your operating bank account and it sat there for 15 years, well, what was the money that you're tracing? Is it this money that came in from the inheritance or is it your paycheck and your spouse's paycheck? So there's a problem with that. If it was a year before separation that you got the inheritance and you put it in the joint account, well, you may have lost because you put it in the joint account half the inheritance, but not all of the inheritance. And the accounting of it is far simpler. So at the end of the day, we always say to our clients, like Anna just said, put it in a separate account. Don't commingle it because then the tracing is going to be really, really easy to perform. And of course, keep all your bank statements every month when you get them. Now, I know some of my clients, I give them advice after they go through their separation and they tell me they live by it. And when I've told people this, some people tell me they live by it. But one of the problems is that we run into is when you're in your first marriage, and let's say you're 20 years into the first marriage and you have a $500,000 mortgage on your house and you got $1 million mortgage and you decide, well, I really want to pay off my mortgage. Maybe I'll buy a cottage, put in a pool and buy a car or two. That's a problem because when you put the money into the matrimonial home, what's going to happen?
It's a commingled asset. You're going to lose that exclusion.
And in fact, once the exclusion hits a matrimonial home, it's gone permanently. The tracing ends with a matrimonial home.
That's right.
So, real problem. And what our viewers need to understand is you can have more than one matrimonial home. So when you go buy that cottage with the inheritance instead of paying down a mortgage, same thing. Now picture this, you go to your spouse of 20 years, you've raised 3 kids, they've been part of your family all this time, you get a $2 million inheritance with the mortgage on the home, and you say to your spouse, hold on, I'm not going to pay the mortgage off because that's my inheritance and I don't want to share it with you. I don't think many people are going to be terribly pleased with you at that point. So I've often thought the legislation is flawed because it begs conflict in terms of what it's creating.
I agree.
But that's what it does. And you need to be able to trace it. You need to be cognizant of it. And if you said, well, I want to put it in the home, what can I do to protect it? It's the same answer we often say. Marriage contract, marriage contract, marriage contract. You can do one after you're married. But again, imagine asking your spouse of 20 years, I need a marriage contract because after 20 years and 2 or 3 kids, I don't trust you with my parents' inheritance.
It's a tough one for sure. And I mean, I guess we'll talk about it in a bit, but the special rules pertaining to the matrimonial home in general can be extended even further, not just only to inheritance or exclusions or gifts. It's a big problem in the legislation with respect to the matrimonial home.
So here we have a situation where what the most commonsensical route to take with an inheritance can't take, because if they do that route, they're risking what could be a significant part of their net worth and quite frankly, their parents' legacy to them. So that's a big problem. Now, you mentioned the matrimonial home. We just mentioned about once an inheritance goes into the matrimonial home, it's lost. And you mentioned something about also dealing with it, I think, for the deductions. Can you explain that?
That's right. So as we talked about earlier, any assets that you had at the date of marriage that can be proven can be deducted from your overall date of separation value, thus reducing your net family property and thus reducing the amount of money that you would have to pay the other side or receive from the other side if it's the other side that has a higher net family property. The problem is that if the matrimonial home that you're currently in is the same one that existed at the date of marriage, you do not get that date of marriage deduction. So you are not able to reduce that value as you would for other properties. Now, if the home at the date of marriage is different than the one at the date of separation, then you would get your deduction for the home at the date of marriage. But if it's still currently your matrimonial home, and as Andrew, you mentioned, you can have more than one matrimonial home, you will not get that deduction. So an example, often is that one person will come in with a property, the parties will get married, and the second spouse will join them in that home. So the equity that this one person brought into the marriage is now lost to them upon a separation if they continued living in this specific property at the date of separation. So there is, again, going back to the legislation and, people really coming into a bit of a difficult set of circumstances with respect to the matrimonial home. And the only way out is the marriage contract.
And quite frankly, one of the things I've often said to people, even though we don't do marriage contracts here, is that's the easiest form of a marriage contract and probably the most likely to be upheld, because the courts can understand what you're trying to do is protect your equity on the date of marriage, if that's all you're doing with it, is saying, I want that date of marriage deduction. So this creates a real anomaly. I mean, I've had a lot of clients come in over the years and they'll say in the consultation, what should I do? I say, well, you go home and you say to your spouse, you want to fix the marriage and we need to start with a new home. And I'm sure I know some have tried it, not succeeded. The spouse wants a separation, but it's a sad statement that you lose this massive deduction and that you need to be aware of this particular issue before you marry, because it can be incredibly costly. The other place that we see it costly in is in some ethnic communities. Their families arrange their affairs by the parents who own the home putting it in their children's name. So if they put it in the child's name before marriage, the child loses the deduction. Or if they put it in the child's name during the marriage, they lose the exclusion. And they're not aware of these horrific consequences. So here you have some parents, they're immigrants to Canada, they worked incredibly hard, they built up some money, they buy a house, all their equity, all of their assets is in the home. And in their community, they believe it's a good idea to transfer that house to their eldest child, because that's good estate planning, let's say. But what they don't realize is then that oldest spouse's child, that child gets a divorce. And now their former spouse says, well, I want my equalization payment on that half. And they're beside themselves. So that creates a really awkward situation. And why we're focusing on this is we want our viewers to understand, even though we don't do marriage contracts, they're a good thing. But the other thing is, before you start deciding to have transfers of wealth between generations, you need to think about the quality of your child's marriage, if someone is watching, or you need to be thinking about these things like deductions and exclusions. One of the things we mentioned before is having proof, and I talked about what I call the Rolls Royce of proof. If I have that bank statement on the date of marriage showing I have $500,000, that's perfection. You're not going to get better than that. But there are ways to try and get proof even if you don't have that. The proof doesn't have to be perfect. It has to be balance of probabilities, which means 50.1%. So if someone said, I had 200,000 in RSPs on the date of marriage and I can't prove it, I say, okay, let's go look at can you get your tax returns leading up to the date of marriage? Because if you have all these tax returns and you show 20, 20, 20, 20, every year 20 going into your RSP on your tax return, but you don't show any withdrawals of RSP income, you're going to get something. It may not be all of it. The same with tracing and inheritance. It may not be perfect, but a judge can look at it. I'll give you an example of one I remember. I had a client, they both were T4 employees. 3 years before marriage, this guy got $1 million inheritance. Okay, well, I knew he wasn't able to trace it. He didn't keep anything. But the problem was he made, say, 60 or 70,000 and she made 30,000. So how is it that this couple that had no income had a large stock portfolio and no mortgage on the home? It had to come from somewhere. So part of that argument would be, well, there was this inheritance. Doesn't mean the court's going to give you all of it, but there's something for it there. So these are things that I think are important for the viewers to understand, that it's not perfection. Now, one of the other areas you mentioned earlier on, Anna, was businesses. Can you talk about how that makes it complicated?
Well, again, when we have various shareholders involved or very complex structures and entities, it's often above even our heads as to, how to ascertain the value. Most family law lawyers are not very good at reading financial statements. That's not our area of expertise. And that's when you need qualified experts such as business valuators to come in and to address what the potential value may be. And to ascertain that, there are things like goodwill. There are things like, how do we ascertain, the values of the various assets. So, what does the business structure look like? Who are the shareholders? What are their respective interests and percentages? So it really does become very complex at times.
Well, what you hit on the nose is that we need valuators to value a business. And there are different ways that we go about having valuators. Sometimes one side will hire their own valuator, and then the other side will hire their own valuator, and it's a battle of the valuators.
Yep.
Other times, the parties will jointly hire one valuator. And our viewers may be watching and saying, well, if there are two valuators hired to value the same business, why are they coming up with different numbers? It should be the same number. But the problem is, valuators make assumptions and they get information from people who are supplying it. And the information can be tailored in such a way to give answers that are not necessarily bang on. So they may have a disagreement over what the goodwill in the business is actually worth. They may have a disagreement on the value of real estate. Typically, the most logical complaint comes from goodwill and where company forecasts are being relied upon in order to determine what the future may look like for that business. And sometimes these differences can be extraordinary. I've seen some cases where one valuator says a two multiplier, the other valuator says a five. And that usually will irritate judges. And we try to get the two valuators together to discuss it. But sometimes the problems are profound in terms of they're just looking at it through completely different lenses, or sometimes they're looking at it more as an advocate, which they're not supposed to do. So we get into these kinds of issues about what is the value of the business. We also always have to keep our eyes on taxes. Now, we're not able to do the tax calculations like a valuator can, but the starting exercise for all of the assets are, what are they worth? But then we also have to figure out what taxes do you have to pay in order to access that money. So, for example, RSPs, they have a notional tax. Businesses may have a notional tax. And every asset, if there's a gain, has a notional tax to it. And valuators tell us what that notional tax is, because it's not so simple as to just say, well, here's my tax rate, here's what it is, because I may not pay taxes on it for 20 years. So how do we discount that? How do we apply that? What are the current tax rates? And then what's the discount? So the valuators get heavily involved. And then we also have joint valuations. I don't know if you want to explain what a joint valuation looks like, Anna.
So a joint valuation is where both parties agree on one particular expert. Sometimes they will both contribute to the payment of that particular expert's work, or one party will fund it, either with the hope of getting reimbursed later on, or they will just fund it, period. And the nice thing about a joint valuation is that there is less of this issue later on where there's the battle of the experts or people are disagreeing. And, one of the other things that you alluded to previously, an expert becoming potentially an advocate. When you're representing both parties, there's less of a risk for that. And I know that the courts very much do prefer joint valuations where possible, and very much encourage that. And I personally think that that is a really great thing as well in terms of mitigating conflict, which in this field we have enough of without the battle of the experts.
So I'm going to start my comment on, I usually prefer a joint expert. I often use joint experts. But there's also a problem with a joint expert. And this is the problem you need to be aware of. At the beginning of the process, you'll have a conference call between the lawyers and the business valuator. And when I'm the non-business owner, I'm acting for the non-business owner, I'm probably going to ask the expert to look at a lot of stuff because I'm going to be concerned that my former spouse is hiding expenses in the business that's really income, because the more income in the business, the more value if there's goodwill. So I'm going to want to drive that number up. And I'm going to want them to look at more stuff. But valuators are not cheap. They cost as much, if not more, than lawyers. So that is expensive. And when you're acting for the business owner, you're typically saying, well, my client's a really honest person. We don't want to waste the expert's time and money and our limited resources on digging and digging and digging. It's a complete waste of time. And you have this very difficult nexus going on that you need to make sure you can get to the right place as to how much time and money that expert is going to spend on that particular valuation. And that's where the art of a joint valuation comes in, is trying to get the right amount that makes the non-business owner comfortable that things are being reviewed properly, but at the same time, not blowing your brains out on the expert, because believe you me, you're going to feel like you're bleeding money between lawyers and experts like there's no tomorrow. And if you're the business owner, you're not going to be thrilled with it. When you're the business owner, you're going to be really upset with all the production of documents you have to do. And everything that your former spouse asked wants more digging is also going to mean you have to do more work to give that information to the expert. So there's a real push between these two areas that we often have to reconcile, because if I'm the business owner, I partly feel like I'm contributing and paying to somebody who's trying to put a noose around my neck, for lack of better words. So you have this balancing interest that has to take place. As I said at the premise, at the beginning of this, I generally do them. I generally like them, but you have to be careful with where it's taking you to make sure you're getting that right balance, because the biggest advantage is that, just like Anna said, at the end of the day, if you have expert A says business is worth 2 million, expert B says it's worth 1 million, unless you're able to have the experts talk and you're able to bridge that gap, there's a good chance you're now going to have a trial that is going to boil down to a judge who is going to prefer one expert over the other, or may pick a number in between. But that becomes very, very risky and very, very expensive for a trial, especially when the star witness is your business valuator. Is there anything else? Did I miss anything on that, Anna?
No, the only thing I would add is that, to avoid that situation, it would still be cheaper for both parties to contribute to a joint valuation as opposed to doing them separately. So if the concern is that one person will be paying and the other person is going to be racking up the bill to try and investigate and look into this further, one of the ways to get around that is to perhaps negotiate some sort of a contribution, even if it's at a later point in time, because that will really cap the non-business owner from, a fishing expedition essentially, or, digging into areas where maybe it's not necessarily to dig into. And if you are paying some of that, you have a little bit more control as to what you can ask for. So.
Okay. We're basically out of time now, and I wanted to comment that this show was about equalization of net family property. This only applies if you're married. If you're not married, there are different remedies available to you that are far more complex than equalization. And so for the viewers who've watched this, this is about married couples only. I wanted to thank you for joining us on the show today, Anna. It was much appreciated, and thank you for your
Having me.
information. The next Ask Andrew show will be September 26th at 12 noon, and we hope to watch you there. And if anyone has any ideas for a show, please send them to info@feldsteinfamilylaw.com. Thank you and have a great day.